Nancy Pelosi. Going live with Nancy Pelosi. Wow. I guess we are.
How about those justices coming before the senators and saying that they respected, sorry to say, the precedent of the court, that they respected the right of privacy in the Constitution of the United States? Did you hear that? Were they not telling the truth then? How about those?
All right. Welcome to the Great American Male Podcast for June 24th, 2022. It is a beautiful sunny day outside. Haven't been outside yet, but I'm guaranteeing you it's hot. My air conditioner is having a tough time getting the house cooled down. So anyway, a lot to talk about. First and foremost, we're going to talk about the Dobbs decision is down. It is in line with what we covered, the leaked Alito decision, more or less as we thought it would come down. We'll give you the basics on that, and as we always do, we're going to walk you through the law, the Constitution, and the history about that. We're also going to talk about yesterday's decision upholding the Second Amendment to the Constitution, tell you a little bit about the differences between the Bill of Rights and abortion and why those rights. So there's a little bit of a breakdown you're not getting out there from a lot of people that you need. And we're going to get to some national security from Biden and racial quote-unquote equity. We're going to tell you what that is. I think you know, most of you have been listening. And we're going to tell you why we're talking about it as it relates to the Fed. And a lot of other things we can get to it. Before I get started, let me apologize for missing yesterday. What happened is a family member unexpectedly came into town, and so I had to spend time with him yesterday. And I couldn't tell you on Wednesday because he didn't alert me until sort of the last minute, which is very, very like my family. But anyway, sorry about that. It was a little bit of a big news day, so I've got a lot of stuff to get you caught up with. And let me just start off the show. And if you're watching this on YouTube, for those of us who are not doing the podcast, but the live stream, you're looking at a quote from Thomas Jefferson. And I had to pull this up on the interwebs. But I remember for a while there, I was living down in Pensacola, Florida, and the drive down to Pensacola, Florida, you basically take interstate south, dead south, and then you basically head due south from there along these old roads that wind through all these various towns, right? There's no interstate that goes directly through it. You have to kind of weave through the backwoods of Alabama and Florida. And there used to be a sign. It's not the picture you're seeing if you're watching on YouTube, but it had a picture of Thomas Jefferson, a different picture, and it had only the first line of the quote that I'm about to read to you. And I remember I used to drive by that and just think, what in the world was Jefferson thinking when he said that? What does he mean by that? I mean, it's so simplistic. And it's funny, I've lived now long enough to realize that it was I who was being simplistic and I who was wrong, and obviously not Thomas Jefferson. I probably should have known that anyway. But as it turns out, the quote is this: the whole art of government consists in the art of being honest. And I didn't think much of it, some 10 years ago when I was doing that drive every other week. But now I think it is so, it's just overwhelmingly true today. And you listen to Nancy Pelosi talking about what she's talking about there is stare decisis, and we're going to get to stare decisis, and Alito deals with stare decisis in the opinion, and Pelosi knows that. And also Pelosi's suggesting, these justices lied when they said that they were going, that Roe was settled law and Roe was the law of the land and they respected precedent. They lied, as if Pelosi doesn't lie every single day, as if Pelosi has any respect for the Constitution. When we get to the racial equity, you're going to see that she doesn't care anything about the Constitution. Right. And again, getting back to Jefferson, Pelosi should just be honest. I say this all the time. I don't need agreement, folks. I want clarity. Let's just be clear about what we're all talking about. And, another way to say that is let's just be honest about it. And so what you're going to see, I'm going to walk you through the basics in a minute. But I want you to see, somebody tweeted this out. I don't know who it was. I can't remember. But they said the reason we don't ever get off Twitter is because the left meltdown is worth it. And I'm not one of those persons that gets into that kind of thing. I just don't like dunking on people on Twitter, and it's not what I'm into. But it is unbelievable how panicked the left is about this. And I want, it really isn't, it's not something that's unexpected. I mean, the leak did a lot of things. One of the things the leak did was it gave you months of time to get ready for this, unless somebody could change minds. And it looks like Roberts could well have been the leaker, because if you read, and I skimmed very quickly, it's about 200 pages of opinions, folks. I skimmed through it quickly, and what it looks like is some of the people in the news will tell you it's a 6-3 decision. It is not. It is a 5-4 decision technically. So you've got the 5 justices, other than Roberts. They're for striking Roe down. Then you've got Roberts, who writes a concurring opinion, who says, well, Roe v. Wade, no, that's right. Casey, no, there's no constitutional right to an abortion, but we don't have to overturn Roe v. Wade, which I hadn't had a chance to read it word for word. I don't know how he comes up with that. But if you want to know what the law of the land is, the law of the land is abortion a constitutional right? That's 5-4, right? That it is not. Which, listen, 5-4 still carries the day, folks. But it's not 6-3, which is what you're going to hear from a lot of people out there. It's just not. Anyway, so getting back to the reaction of the left, a couple of things I want to point out before I give you the basics of how abortion law works and what it means going forward. I want to take a look at a couple things that are going on here. So one of the things that's going on as it relates to honesty is you're not seeing the left deal with the reasoning of the court, right? You're not seeing the left come out and go, well, Alito wrote the majority opinion, right? And then Thomas wrote a concurring opinion, Kavanaugh wrote a concurring opinion, and Roberts wrote a concurring opinion. The Thomas and the Kavanaugh concurring opinions don't change the root of the majority opinion. So the majority opinion is there's no constitutional right to an abortion in the Constitution. That's what the majority opinion is, okay? And the concurrences, we might get into those next week when we can sit down and read them word for word. But it really, at the end of the day, doesn't matter. And because there's no constitutional right to an abortion, it then is permissible to regulate it under the police power that every state holds. So the law of the land now is that if a state wants to pass a restriction on abortion, there's no constitutional right to stop them from doing that. So they can eliminate abortion in its entirety if they so desire. We shall see what happens. Some states may well do that. Some may have exceptions for the life of the mother and other things. Some may give you a certain amount of. I suspect the majority of the states will have a limited amount of time to do it, 8 or 12 weeks, and then some won't change at all. I doubt California or these blue states will change it all. But I want you to go through a couple things that the left here is saying about this. All right, so let's go to Larry Tribe because the left, they just worship Larry Tribe. I mean, he's like a god to them. I mean, he's not Obama. But they worship him. He writes a lot of textbooks. Supposedly, he's a constitutionalist. So here's his quote. Breyer, Sotomayor, Kagan, the 3 leftists who said that, Roe is sacrosanct, with sorrow for this court, but more for the many millions of American women who have today lost a fundamental constitutional protection, we dissent. All right. Now, okay, let's take this down. So, with sorrow, okay, all right, you have sorrow for the court. All right, so when we're on the left and you lose, you get to go and we feel sorry for the court. Okay, so that's not really a powerful argument, so we haven't heard any argument yet, but you're sorry for the court, and apparently you have sorrow, all right, and for the many millions of women who've lost a fundamental constitutional protection. What is it? What's the constitutional right? And if you remember when this case was being orally argued, and I looked to try and play it today, and I've got too much to cover, and I've only got 40 minutes, so I couldn't pull it up. But Justice Thomas asked, I thought, a very good question from the bench. He said, "What right are we talking about here? Where in the Constitution? What right is it?" He goes, "If we were talking about the First Amendment, I'd know what right we were talking about. If we were talking about the Second Amendment, I'd know what right we were talking about. If we were talking about the Fifth Amendment, right, I would know what we're talking about. What are we talking about? What right here?" And the Solicitor General, who was arguing the case for for keeping Roe v. Wade alive, basically couldn't answer the question. And I don't think she was an unintelligent person. There is no answer to the question, and that's the whole problem with this whole quote unquote right to privacy that they invented in the first place, right? So let's go. So Larry Tribe, he doesn't give us a good one at all. Okay, this is what Bernie Sanders, crazy Bernie, so what he's got to say. Overturning Roe v. Wade and denying women the right to control their own bodies is an outrage and a defiance of what the American people want. Okay? Now, Democrats must now end the filibuster in the Senate, codify Roe v. Wade, and once again make abortion legal and safe. Okay. What constitutional right would you have to codify Roe in the Senate? Again, they don't have any. And again, there's no argument there. What constitutional power do you possibly have that overrides a state's police power? What had overridden a state's police power from Griswold, which I believe was 1965, but Roe certainly in 1973. What had overridden it, according to the court, was this right to privacy, which extended to birth control in 65 with Griswold and abortion with Roe in 73, and then again in Casey in 95. So that's what overrode the police power, right? But now he's just talking about codifying it. They're not going to be able to codify it. Now, he's signaling you where they're going to go. So let's get to the first thing he says. Overruling Roe and denying women the right to vote is an outrage and in defiance of what the American people want. Well, how does Bernie know what the American people want? I mean, if you look at these states, they're closer to the people, and apparently that's not what they want. A lot of states want to put restrictions on abortions, and they're going to do so. So that's not very persuasive at all. Okay? So then what does Grandma Vodka have to say? Well, we heard from her to begin the show, right? She said that they lied. Well, we all know politicians lie, right? And by the way, why did they lie? If you're listening on YouTube, I know the first video we ever published, the first one I ever did, was I basically walk you through how Biden just literally destroyed the confirmation process. And if you want to understand Biden as a politician, I would urge you to go look at the first video we posted on YouTube, and you'll see it. It's about a 15-minute video, maybe shorter than that, not very long. But it's him spawing with Thomas Sowell. And I mean, you want to talk about an intellectual mismatch. I mean, I think Sowell's probably spotting Joe Biden about 50 IQ points there. But he was the one that started making these things a show. He was the first January 6th committee, if you will, because he didn't like Bork. But and it's funny too, because Reagan ran on overruling Roe v. Wade. He literally ran. He said, as to the Supreme Court, I'm going to do two things if you like me. One, I'm going to nominate the first woman on the court. He did, and he followed through, and he did it with Sandra Day O'Connor in 1981. And he goes, I'm also going to nominate judges that will overturn Roe v. Wade. It was fresh then. It was only about 8 or 9 years old at that point. And he did, but he wasn't able to do it. But because people like Joe Biden, who was then the chairman of the Senate Judiciary Committee, which hears and votes on nominees of all sorts, but especially judges, he went after Bork. And what happened after Bork was no more releasing what you think, because you'll just get destroyed and they'll turn it into a show trial. And he's the one that had, primetime hearings, made them primetime events. And then, of course, Thomas, that's when you get to bring somebody in who gets to accuse you of something, even though you've had 4 background checks and you've passed all 4 background checks. Doesn't matter. This person can now come forward and something that had never been prosecuted and can be completely debunked, and we're going to have a national spectacle on national TV. None other than Joseph R. Biden. He's the architect of that. And what became of that, well, of course, it led to Kavanaugh. Well, you saw what happened to him. But what became of that is it really harmed us all. Again, getting back to the art of government being honest, people couldn't be honest about what they thought. They had to say, oh, well, I don't know. I respect the precedent. And so Pelosi's got no point there. But let's listen to it again, because I do want to break down one point that she has real quickly before I move on to the Second Amendment cases. So let's listen to Nancy again. I think it seems like she's only 1 or 2 shots in at this point.
How about those justices coming before the senators and saying that they respected, stare decisis, the precedent of the court, that they respected the right of privacy in the Constitution of the United States? Did you hear that?
All right, so basically she's bringing up stare decisis, and that is one of the problems that the court had to deal with today. And as it turned out, the concurring opinion by Justice Roberts actually uses stare decisis to say that he would keep Roe afloat. All right, now let's tell you what stare decisis is. Stare decisis is a Latin term which means the issue has been decided. So the idea behind stare decisis is, let's say something comes before you and it's a novel issue of law. And you say, well, I could go this way, I could go that way, and you decide to go with position A, and you decide to disregard position B. The point of it is, after a few years, people have relied on position A because you told them that was the law of the land. And you go decades and decades and sometimes hundreds of years with position A being the law of the land, even if they were close at the point. Now people have relied upon this law. They've done things, and you shouldn't just change it, right? That's the idea of stare decisis. Now, stare decisis never bothers leftists. It's one of the examples of the communist brilliance in that they use your values against you. I mean, to hear Nancy talk about stare decisis is laughable, because Democrats rewrite stuff left and right. They overwrite stuff left and right. They just pull things out of a hat left and right. But then if you ever try to do it, oh, hell hath no fury. So anyway, but I want to basically break it down to you and explain to you basically why stare decisis doesn't apply here. And the easiest way to do it that most people don't understand is Plessy versus Ferguson, okay? Now, you probably haven't heard of actually, you folks watching this, y'all have heard of Plessy versus Ferguson, but the average person has not heard of Plessy versus Ferguson. But the average person probably has heard the term separate but equal. Well, separate but equal came from the Plessy versus Ferguson Supreme Court case in 1896, right? So Plessy was a black gentleman who got into a white car, and he was told that he was not allowed to be there because this was the white-only car. He refused. He was arrested. Case got all the way up to the Supreme Court. The Supreme Court said, yeah, they can do that. Separate but equal. Doesn't violate the Constitution. Now, they were wrong in 1896. They were wrong in 1897, 98, 99, 2000. You go right on up until 1954. And another case to test this idea comes up. It's called Brown versus Board of Education. And they said, hey, stare decisis. We decided this 58 years ago. Separate but equal. So no, black child, I'm sorry. You do not have the right to go to a white school. That's separate but equal. And the Supreme Court said, no, it's not. Now, at that point, there had been 57 years of people relying on the fact that you could segregate the races if you so choose, right? Now, the Supreme Court at that point, did you hear anybody on the left come back and go, oh, stare decisis, you can't do that. You can't reverse this. You can't reverse that. I mean, it was never a good doctrine from the beginning. Separate but equal. Never made any sense. How could it be separate but equal? By definition, if it's separate, it's not equal, right? I mean, anyway. So Nancy talking about stare decisis on something like this is wrong because they do it all the time, right? And then B, they're only trying to use it to try to ham you in. And then C, folks, if a case was wrongly decided, you need to correct it. Now, thank goodness they corrected this one in 49 years. It did not take them the 58 years. It took them to correct Plessy versus Ferguson. But that's all you really need to know about that. So before I get into the gun control decision, let me real quickly walk you through how the Supreme Court works here. I've already told you what the ruling is. The ruling is there's no constitutional right to an abortion. All right. And because of that, then the state, through their police power, can make a law that says you can't have an abortion. Just like they can make a law that you can't murder, just like they can make a law that says if you have more than, 0.07 or 0.10 of alcohol in your system, you may not operate a motor vehicle on our roads. It's all the same as that. So why is that different from the Second Amendment, right? What's the difference going on there, okay? And so the main difference about Roe v. Wade, there's one thing that you have to go through to deal with that, which you don't have to deal with the Second Amendment, okay? So the Second Amendment is a right that is embedded in the Constitution, the Bill of Rights. It is obviously the Second Amendment to the Constitution. So it is a right that is given to you, right? And so I say I have a right to bear arms. That means if the state wants to do something to restrict that right of mine, in this case to bear arms, the law has to pass strict scrutiny, which means it has to be the most minimum way to achieve a compelling governmental interest. Now, it doesn't mean they can't restrict it in some way. So we've talked many times that strict scrutiny can be met, but it's very, very limited. And so we've talked many times about the idea of regulating speech. There are some things that will meet that burden, right? Where the state is satisfying a very compelling interest, and they're doing it in the least intrusive manner possible. So we give this example all the time: time, place, and manner. They can say that you just can't go to the park and start broadcasting anytime you want, but we're going to have a time, a place, and a manner, like a process you sign up. And as long as we don't discriminate in that process, that's perfectly legal. And so the same thing applies with the Second Amendment. The states can have reasonable restrictions if they so choose, right, on the Second Amendment. But the general idea is they can't completely restrict your entire right. We're going to get into that in a moment. But I want you to understand one of the reasons why the left is panicking over this Roe decision, and there's going to be some misinformation out there, is the abortion issue had to go through one fundamental thing, and that is this, okay? The state has the police power, so they get a right to do it. If you come in and say, hey, I've got an individual right that overrides your police power, what is it? Right. Well, again, if we talk about the Second Amendment or we talk about the First Amendment, we know what the analysis is, and we're going to go through that in a minute. But since there's no right in the Constitution, the court says we don't need to look at that, right? But in doing that analysis, the court had to do one thing that Alito did, and that is it had to say, if the states are going to be restricted under the Constitution, where would it be? And the courts, and we've talked about this many times, there are 3 Civil War amendments: the 13th Amendment, the 14th Amendment, the 15th. 13 ended slavery. 14 gave you the privileges and rights of citizenship, because they were like, hey, yeah, you want slaves no more, but that doesn't mean you're citizens. 14th Amendment took care of that. 15th Amendment gave black people, gave you the right to vote basically regardless of race. You couldn't restrict it on race, okay? So it meant black, but it also means Native American, Asian, whatever you want to do. You can't do it. Now, so what the courts have determined as it relates to the 14th Amendment that guarantees you, and by that I mean every one of us, everybody listening to me and anybody who might listen to me in the future, all the Americans, they say, all right, when the 14th Amendment passed, that made the Bill of Rights and the Constitution applicable to the states. Prior to then, it hadn't been, right? That was only applicable to the federal government. So you understand, only the federal government couldn't impede your right to speech, but your state government could. Now, many states and most of the states had individual state constitutions that also gave you those protections, but they didn't have to. Okay, so this is a big deal. And so the way you understand whenever you get into these cases like Roe and Dobbs now is that the court has said, okay, here's the way we're going to determine that. If the rights and privileges and citizenships of being a United States citizen are those rights that existed when the amendment was ratified in 1866 is when it was ratified. It might have been 1865. Civil War ended April 1865, so it took them a while to get it passed and out to the states to get ratified. It was either late 65 or 66, doesn't matter. And so in doing the Roe v. Wade analysis and in doing the abortion analysis, which they finally did correctly, Alito goes through and says, there was no right to an abortion at that time. So even if you have this right to privacy, is what he's saying. He's saying there is no right to privacy in the Constitution. But even if it did exist, it didn't exist at this time, right? And so since it didn't exist in 1865 or 66, you don't have it, right? Understand? So the same thing, a little bit of a similar analysis, but I want you to understand that. And so partially because of that, that's why you're going to hear a lot of these people out here talking about what existed in, 1865, and they're trying to send women back. That's not what they're doing. What they're doing is they're saying, you got to show me where this was a fundamental right, because if it wasn't a fundamental right, you don't have it. And the best example I can give you is Obergefell, where they basically do the same analysis, and they go, oh yeah, there was the right to marry, so gay people can marry. And all of us are like, I'm not taking a position on gay marriage, by the way. I'm not. I'm not. My opinion is irrelevant. But I am telling you this. If you think that in 1865 or 66 there was a right to gay marriage that most states recognized, then you're out of your mind. There's just no way. And so they cheated to do the analysis then and switched it to there was a right to marry. Yeah, there was a right to marry, but it wasn't to marry somebody of the same sex. So anyway, so there's one other important thing you need to know out there. And then before I leave it, and I can't believe, see, this is why the left wins these things. I'm literally 22 minutes in, and I could literally talk for hours about this case and about the law about this. And I'm 22 minutes in. It's unbelievable. Anyway, one more thing I want you to understand before we move on from this Dobbs decision. Again, I don't think it's as big a news as a lot of people think it is, because we knew it was coming. But one other thing I want you to remember, when the left is out there, they're attacking. They're not going to attack the argument. They're going to attack the institution and further trying to degrade the court. But the last thing I want you to remember about this, and always keep this in mind, and the left does a good job of this, they're making it seem like the most conservative decision in the world. It's extreme. It's crazy. No, it's not. Let me tell you what they could have done, and they might have done if they were so-called conservative, really, really conservative or whatever, and extreme. They could have said that the moment, right, a sperm fertilizes an egg, that's a human being. And under the 14th Amendment, that human being has rights. There'll be no abortions. They could have outlawed abortion. Easily could outlaw abortion if they wanted. And that's how they do it. They'd say, oh yeah, it's a person. And when it's a person, it has 14th Amendment rights, which means you can't go get an abortion. You can't kill another human being. Just like I can't go out, get in my car and run somebody over. And so when you look and when they talk about these things, they do a very good job of fooling people. Oh, it's so extreme to send it back to the states. Why is that extreme? Why wasn't it extreme when you took it away from the states? Oh, well, that was just a moderate, reasonable decision. That's what that was. Nothing wrong with that. So just keep in mind, folks, that the moderate position, if you want to take a look at it, is what the Supreme Court just did. They said, look, hey, there's no right. You go deal with your state. If you don't like that state, go somewhere else. Actually, there's one more thing I did want to cover from this just real quickly. And by the way, if you want a detailed analysis of the right to privacy and abortion, we've got a single issue podcast up there on our greatamericanmail.substack.com, greatamericanmail.substack.com. I've got a really good 30-minute single issue podcast that walks you through Griswold, it walks you through Roe, the whole bit. But one other point that's important to realize is that in the 49 years that we've been dealing with Roe, I want you to notice how Roe originally said viability was the standard. So once the fetus got to viability in the third trimester, you could regulate abortion. You could, right? So if viability is still the standard, that would have been moving back by now. And you also understand that it is much easier to recognize you are pregnant and get health care today than it was in 1973. But because there's more abortion clinics, just because there's easier pregnancy tests, all the things. Just imagine how it would have been to get a doctor's appointment to determine if you were pregnant in 1973. And so part of what the court is reacting to here is the fact that we've largely botched the abortion issue in this country. And it was and you're starting to see these really, really bad laws. I mean, if states had been reasonable about this and started to encourage people to, hey, realize if you're pregnant, get early treatment, get early health care if you want to do something about it, I don't know that we ever would have reached this point. And I'm going to make this point again when we get to the Second Amendment, because the New York law was so over the top. It's like if you hadn't been so over the top, the court might not have had to do what it did. Anyway, so we're done now with the abortion issue. Let's move on to the Second Amendment ruling that came out yesterday. So yesterday, the court again ruled with the 6 reasonable people who actually believe in the Constitution and the 3 fascists and communists who would do anything they could to destroy the Constitution if they could. So in a landmark victory for gun rights advocate, the United States Supreme Court today ruled 6-3 that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. Now, that's important because, as I already explained to you, that's why the 14th Amendment is mentioned. In other words, if this had been a law that the federal government had passed, there would be no mention of the 14th Amendment because you wouldn't need it. The Second Amendment would be all you need because that we've always agreed from the very beginning the constitutional amendments and the Constitution apply to the federal government. So just so you understand this, if Joe Biden and his gun grabbers in the Senate, which include 15 Republicans apparently, in the House, try to pass a law like that, under this case, it would be illegal. But it would only be unconstitutional based on the Second Amendment. You wouldn't need the 14th. If it's a state, New York, Georgia, Florida, whatever, now you need the 14th Amendment to make it applicable to them. Anyway, so I'm going to skip down a little bit. So the case centered on a New York law requiring anyone seeking a license to carry a concealed handgun in public to first satisfy a local official that he has, quote, proper cause to do so. According to the statute, a generalized wish to carry a concealed weapon for self-defense was not sufficient to meet the proper cause standard. And 43 states observed the majority opinion of Justice Clarence Thomas. The government issues licenses to carry based on objective criteria. But in 6 states, including New York, the government further conditions issuance of a license to carry on a citizen showing additional special need. Because the state of New York issues public carry licenses only when applicants demonstrate a special need for self-defense, Thomas concluded, we conclude that the state's licensing regime violates the Constitution. And it is this next paragraph, and we're going to get to in a minute, I really want you to pay close attention to, because Justice Thomas is a godsend to those of us that believe in the Constitution. I mean, he is, I don't think there's any question, he's the best justice on the court now. And if you were to ask me in my lifetime, between him and Scalia, it's a coin flip, and they're both very good. And Thomas has been excellent. There's some issues that he and I disagree because libertarians, we often are a little bit more anti-government than traditional conservatives like him. But anyway, he has been very good. And this point he makes here is a great point. So at the heart of the case was the question of whether the discretion that New York placed in the hands of local licensing officials was consistent with how constitutional rights are typically treated in the American system. New York's licensing scheme failed that test. And again, this is the quote from Thomas, quote, we know of no other constitutional rights that an individual may exercise only after demonstrating to government officials some special need, Thomas wrote. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It is not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him. It is not how the Second Amendment works when it comes to public carry for self-defense. I mean, well put. And he is exactly right. That is the whole reason you have a Constitution. I don't need to go to the government and tell you about the special need I have for doing a podcast. It's none of your flipping business. Okay, I don't need to do that. It is the government has to come to me and tell me why they get to infringe upon my rights, is what it needs to happen. I mean, as it relates, and I was saying about abortion, this is the exact point I was making. I have a concealed carry permit in Georgia. It's in Georgia, you have to go down, get fingerprinted, you have to get another background check, you have to pay a licensing fee, they take extra pictures of you. I think that's about it. Now, I was on my way to getting it when I was living in Florida, when I was telling you about the Jefferson sign I drove by. I was on my way to getting a carry permit there. They also, in Florida, have the additional requirement that you have to go and pass a gun safety class. And in fact, there were 5 of us in the class that I was in, and one of the persons didn't pass because he couldn't. I think the last thing you had to do was put, 2/3 of the rounds through a bullseye. I mean, not the actual bullseye, but within about a 2-foot circle. And it was only from like 20 yards, and for whatever reason, he wasn't able to do that. But anyway, so the state can have, what Thomas is saying is the states can have some conditions, right? But they can't just tell you can't outright get it. The other problem that they had was that it was individualized by the persons. And so you understand how this would work. You can't just say at a state, the ability to get a carry license is by proper cause, because that doesn't define what proper cause is. Had New York said proper cause shall mean, right, at a minimum, a background check, a picture, a reasonable fee, and passing of a gun safety test, that would have been potentially legal, because now you've told me what I need to do in order to get it, right? But the fact that they had just gotten to the point where it's proper cause and each different individual could just decide who had proper cause and who couldn't probably made the court more likely to take this case and to knock this down. And the point I'm making here, folks, is that the left, they're getting so over the top and so outrageous with the things that they're doing with the law that they're bringing this upon themselves. If New York had just wanted to really protect people and do the things that I said, put some barriers in place, a lot of people aren't going to go through those steps. I mean, you want to eliminate people's right to carry, just tell them they got to pay like $100 to get the thing, and you'll knock out 90% of them, right? But anyway, so that's all you really need to know about that. But before we leave that, I want you to listen to Kathy Hochul, who I got to be honest, I think she's possessed. If you're watching this on YouTube, you'll see the face, and I urge you to look it up wherever you get your news. I mean, this person's not well. But anyway, here she is talking about the Second Amendment decision here.
This could place millions of New Yorkers in harm's way. And this is at a time when we're still mourning the loss of lives, as I just mentioned. This decision isn't just reckless, it's reprehensible. It's not what New Yorkers want. And we
okay, now, just a couple things here. How's it going to place more people in danger? You do understand, folks, the reason that it's illegal is they don't want you, well, actually, it may be illegal in New York altogether. But down here in the free state of Georgia and in most places in the South, I want you to understand about concealing. Concealing means you have a firearm that's not out and open. If you want to walk around here in Georgia like the outlaw Josie Wells with 2 6 guns strapped on, that's perfectly legal and always has been. You're welcome to do that. What people don't want you doing is taking that weapon, that pistol, and concealing it so somebody can't see it. But listen to Kathy Hochul. How many people out there are going around with concealed weapons and you've already got a law against it, and is it stopping anything? No. All she's interested in doing is stopping law-abiding citizens from doing it. And she knows it. I mean, she's honestly lying to you right now, and she knows she is. Again, the whole art of government is the art of being honest. Just be honest with us, Kathy. And it's not what New Yorkers want? Then don't go get one, New Yorkers. Don't go get it. It's very simple. You don't want a carry permit, don't get one. I do. I got mine.
Right of determination of what we want to do in terms of our gun laws in our state.
All right, now, here's the problem, Kathy. Hate to break it to you. There's a little thing called the 14th Amendment, that we passed after the Republicans defeated the Democrats in the Civil War and freed the slaves. They believe in the Constitution, and they said the Constitution is now going to apply to the states. Why do you think they did that? Well, because the states that seceded from the Union, remember we talked about this the other day with Abraham Lincoln, there were 2 things. A new birth of freedom, that means the end of slavery, and, by the way, we're not getting rid of government of the people, by the people, and for the people. We're going to institute it in your states. And so all the states that came back into the Union afterwards had to swear, and the 14th Amendment was part of that. This is the way you're going to treat people. So you're not going to deny them their First Amendment rights, Second Amendment rights, Fifth Amendment rights, etc. And Kathy Hochul, she doesn't understand that. You know why? Because she doesn't want you to have rights. She doesn't believe in government of the people, by the people, for the people. Kathy Hochul tells you what you will do, and you'll be lucky if she gives you any kind of right.
Government will not have sweeping laws to protect us. Then our states and our governors have a moral responsibility to do what we can.
What moral responsibility? You don't have moral responsibility. Just fix the roads, educate the babies. Give me a break, Kathy.
Laws that protect our citizens because of what is going on, the insanity of the gun culture that has now possessed everyone all the way up to even to the Supreme Court. The law we're...
Now, Ian, I haven't heard an argument. Have you heard an argument here? No, you heard me lay it out, 14th Amendment, Second Amendment, how the Constitution works, 1865, all this stuff I've laid out. It's reprehensible. It's insanity, the culture. No argument. Never any argument.
It's been in place since the early 1900s. And
now apparently it had been a 100-year-old law. It was unconstitutional then. It's unconstitutional now. Again, that's the point I'm making, that the governor doesn't seem to understand. If you keep pushing the limits on these things, people are going to start reacting. You could have done it, but no, that's not what they're going to do.
Our ability to determine who is eligible for a concealed carry permit. This is not an ordinary permit. This is a special use that you can hide it from people. We have limitations if it's for a proper cause, someone who's been threatened, someone who needs it for their job as a security guard. We have classifications where it is allowed and have been allowed for over 100 years.
All right, so the last thing I wanted her to get to that, and then I'm done with her. She's lying. And again, folks, the way it would work is you would have had another line in the statute. Proper cause shall mean having been threatened, carries great deal of money, lives in a neighborhood. That would be a law. What she's talking about there, it just said proper cause and every local official. So you understand, if you were in County A, that person may give it to you. If you're in County B, that person won't give it to you. If you're a famous person, they give it to you. If you're not, they don't. That's not the law, and that was another problem that they had. Okay, a couple more things, and we're going to wrap up the show. One is, you need to know this. I would have covered this yesterday, but the Fed should be an inflation fighter, not a social justice worker. This is from the National Review, which apparently now has gone over to a pay model, which is beyond irritating. But anyway, a House bill that seeks to bring equity and inclusion to the Fed is a grave threat to the responsible monetary policy. Amid the worst inflation of 40 years, Congress is considering a disastrous change to the Federal Reserve's mandate. Elected officials should be instructing the Fed to focus on price stability. Instead, they're trying to appease the far left by pushing the Fed into social justice activism. A bill passed by the House of Representatives would codify woke policies into the Fed mission. It would become the law. If it becomes the law, the Fed will become even less capable of controlling inflation. The Financial Services, Racial Equity and Inclusion and Economic Injustice Act has a name pleasing to some ears, but if it's a grave threat to responsibility, monetary policy. Anyway, long story short, they passed a bill in the House, largely on party lines, that basically says that in addition to all the things the Fed is supposed to do, it is supposed to consider racial equity and inclusion. Now, it's an absolute affront to the Constitution of the United States. It is an absolute violation of the 14th Amendment that says you cannot use race as a mechanism for distributing government largesse. That is exactly what they're trying to do, folks. And again, I just wanted to bring this story to your attention. It probably dead as fried chicken in the Senate, probably goes nowhere. But do not mistake the fact that the Democrat Party is now full on about being racist. Anyway, here's President Biden on fuel prices. Take a listen.
The companies running gas stations and setting those prices at the pump. This is a time of war, global peril, Ukraine. These are not normal times. Bring down the price you are charging at the pump to reflect the cost you are paying for the product. Do it now. Do it today.
All right, Quinnipiac just came out with a poll that this person is at 33%, and I don't know what's wrong with that 33%. Folks, the reason this is important is you are teaching people that people at the pump can set whatever price they want. I'm not going to sit here and insult your intelligence and explain what's wrong with all of that. I'm just going to get to the last story. But, folks, this is not good. The President of the United States is continuing to lie. Again, honesty. We need honesty. Last story. Biden calls clean energy a matter of national security. Folks, the reason this story is important, I don't have time to get to it today, but the reason this story is important is they're now trying to make clean energy, now it's a matter of national security. It's nonsense, but it's just more and more of the pushing the green energy which is all designed to steal your rights and enrich their friends. It's just as simple as that, but get ready to hear, green energy being called a national security concern. Anyway, you are now all caught up to date with all the news of the day, and if you liked it, this show, I hope you will tune back in tomorrow.